और इस वक्त की अहम खबर, अंतर्राष्ट्रीय कोर्ट में कुलभूषण जाधव केस की सुनवाई जारी है। हरीश साल्वे इसमें भारत का पक्ष रख रहे हैं और साथ ही भारत की तरफ से यहां दलील दी जा रही है कि कुलभूषण जाधव को पाकिस्तान में जासूस करार देने के बाद जो फांसी की सजा दी गई थी उसको खत्म किया जाए।
Article 36, a dead letter. The more serious allegations, the greater the need for ensuring that an accused has full and meaningful right to defend himself against charges brought against him. To exclude the operation of Article 36 in matters of serious charges of terrorism that would fly in the face of criminal jurisprudence. There can be no doubt that Article 36 was engaged in the present case. An Indian was detained, purportedly arrested, a confession extracted, then he was tried and convicted by a military court, awarded death sentence. And all along, requests for consular access were rejected. This, quite plainly, is an egregious breach of Article 36. Pakistan's fundamental approach, where it says that the Vienna Convention is not engaged in such cases, is erroneous, for it looks outside the treaty for state practice to support consular access, which we say is an irrelevant exercise. It fails to engage with the consequence of its statement that the issue of espionage was present to the minds of those who negotiated the Vienna Convention, and yet no exception was made to the Vienna Convention to deal with cases of espionage. India does not base its case on customary international law or on state practice, but on the plain language of Article 36. Pakistan asserts that the effect of the Cold War on the exercise of codification of international law cannot be overstated, but again fails to acknowledge that if despite this, no express reservation was made in Article 36 of the Vienna Convention for charges of espionage, it establishes that, unsurprisingly, states did not want a vital safeguard recognized in Article 36 to be a hostage to allegations of espionage made by the host state. The absence of such exceptions in the Vienna Convention is unsurprising because the fundamental principles of due process recognize that the more serious the charge, the greater the need for procedural safeguards. Besides, there are some basic rules that must prevail between civilized nations and cannot be displaced by unilateral allegations leveled by the receiving state. Recognizing that the needs of security and efficacy of investigation may require the receiving state to withhold the notification of arrest by a few days, the draftsman of the treaty built in some play in the joints by using the phrase, open quote, without undue delay, close quote. A state may be able to explain a few days gap between the arrest and the notification if time is spent bona fide in investigating matters relating to espionage before the sending state of the national is notified. It is one thing to explain the lapse of time between the arrest and the notification to the home state, and quite another to suggest that charges of espionage jettison Article 36.